All right, welcome everybody to this month's Clinical Corner. My name is Kaile Hilliard. I'm a licensed clinical social worker and a former surveyor out of the state of Colorado. Welcome to today's, Clinical Corner, and we're going to talk about conducting a thorough abuse investigation. I won't be monitoring the chat throughout this presentation, so at the end I'll take a look at it, and we'll go through any questions too that you might have at that point. Just a little legal information. This is for educational training purposes only. It is not a substitute for legal advice, regulatory guidance, or organizational policy. While this content is based on federal and state regulations, survey protocols, industry best practices, facilities are responsible for ensuring compliance with all applicable laws, regulations, and internal policies. I and Granite Peak Healthcare Solutions assume no liability for actions taken or not taken based on the information presented. So we're going to talk about components of a really solid abuse investigation. So we're going to talk about the regulatory requirements, some protective measures, what kind of documentation you need to have in place to kind of round out a really good abuse investigation. But first, we have to talk about when do we conduct an abuse investigation? And this is probably one of the number one areas that I'm seeing people are struggling with. Any allegation of abuse, including verbal, emotional, physical, or sexual abuse, neglect, misappropriation, chemical or physical restraint, is when you conduct an investigation. And it's the allegation that's important. So even if you know that it's likely it didn't happen because you know the person or whatever the situation might be and you already have it kind of figured out beforehand, if the allegation is made, you still need to report, you still need to do an investigation. Also, there are possible physical indicators of sexual abuse that would require investigation. That includes bruises around the breast, genital area, or inner thighs, unexplained sexually transmitted diseases or genital infections, unexplained vaginal or anal bleeding, and or torn, stained, or bloody underclothing. Also, injuries of unknown origin require an investigation. Furthermore, another area where when we're doing our mock surveys, we're kind of finding some issues is on grievances. So you need to review your grievances from a could this be an abuse lens? And if it could be an abuse lens, if you think it's even a gray area, it should automatically be transitioned into a reportable investigation that you're going to rule out all the potentials for. So we can't have this conversation without talking about the regulation. And there is a specific regulation around abuse investigations. It's F610. So if F610 says there's no specific investigation process that the facility has to follow, but the facility must thoroughly collect evidence to allow the administrator to determine what actions are necessary for the protection of residents. Ultimately, you want to know what happened, who was involved, when it happened, where it happened, and how often. You also want to know what occurred prior to, during, and immediately following the alleged incident. So, key elements of an abuse investigation per F610 have these components that they say you need to have as a part of it. So, observations. What's the resident condition? What is the nature of their injuries? What was the environment like? What are staff to resident or resident to resident interactions, depending on what the situation is? You also have to have interviews. That includes the resident, representative, alleged perpetrator, witnesses, staff, outside agencies, ER, hospital staff. You also need to have record review. That includes progress notes, financial records, incident reports, hospital ER reports, labs, MARS, photos, agency reports, anything that is related to the incident. And we'll talk a little more in detail about specific documentation, things that you're going to want to have as part of your investigation. The facility responsibility, even if it is reported to law enforcement, the facility still has to conduct its own internal investigation. So just because law enforcement is involved does not mean that you no longer have to do an investigation. So it still means that you have to do an investigation, and it has to be complete. All right. 610 also says that we have to protect the residents during an abuse investigation. So there are some places where they will cite failures of our facilities, and that includes we didn't protect the residents from the alleged perpetrator. So this means did we suspend pending investigation? Did we separate the residents that were involved? Did we supervise visitation from family that we think might be doing something that's not okay? So those are an alleged failure. Is there evidence that's a retaliation against somebody for reporting abuse? Lack of supervision is a big one. And then ending those protections before the investigations are complete are also areas where we see surveyors liking to cite these tags. And they are, abuse is one of the top 10 cited tags across the nation. So, um, if well, like a facility fails to protect the residents if it does not evaluate the effectiveness of those interventions. So if what you're doing, like say you put somebody on 15-minute checks and they continue to be able to abuse people in between that, or there's another incident in those 15 minutes of not having supervision, the surveyors are going to ask, were you reviewing the effectiveness of the intervention that you had in place? And were you doing everything you could to protect the residents? You have to make sure that you provide immediate safeguards to ensure their safety and prevent further perpetrator to resident abuse. Safety restrictions that you can consider are denying or limiting access for a visitor suspected or found to be abusive, and any restriction in that vein has to be discussed with the resident representative prior to implementation. So, and then you have to have a plan that's well documented. Okay, 610 lastly talks about the corrective action. If a violation is verified, so like you substantiated abuse, the facility has to take appropriate corrective action to protect all residents. And then they have to monitor and evaluate the effectiveness of those corrective actions. So I always encourage facilities to keep evidence of this process as part of the investigative file so that you don't have to go finding it later. You also need to consider whether systemic changes are needed to prevent reoccurrence. So abuse trends, abuse incidents, all should be reviewed in your QAPI. You should be looking at your reporting and investigative process, what kind of resident protections you put into place, implementation of corrective actions, and be discussing that during QAPI to ensure that like we are moving our process forward and in a good manner. So there are other regulations that have some investigative components, and F600 is one of the big ones, and it specifically talks about sexual abuse investigations. And the very first step in that is to determine if sexual activity was consensual. Consent is invalid if the resident lacks capacity to consent. Consent obtained through intimidation, coercion, or fear also makes consent invalid. So the facility has to investigate whether non-consensual activity is suspected and protect residents during that investigation. And then they have to assess both the capacity and the actual consent as part of fact finding. And if we find that like people are engaging in healthy sexual activity, that's not necessarily the problem, but they have to be able to understand the decisions that they're making, the consequences of those potential decisions. And then we have to reassess that regularly if they are engaging in sexual activity. If they do not have capacity to consent, this regulation is very clear that they are not allowed to be engaging in sexual activity. Injuries of unknown origin also has specific investigative components. So you want to investigate when the source of the injury was not observed by any person, the source of the injury could not be explained by the resident, and the injury is suspicious because of the extent of the injury, the location of the injury, the number of injuries observed at one particular point in time, or the incidence of injuries over time. And then if you do have an injury of unknown origin, you're going to want to interview any and all staff who saw or provided care, usually in the 24 hours leading up to that when we identified that there was an injury of unknown origin. And you want to get detailed information. So it's not just like, yeah, I saw them, I provided care. You're going to want to ask some more detailed information on what kind of care did they provide? What was their response to the care? Did they have any reactions, nonverbal signs of pain, etc.? So you want to get more detailed information, specifically where injuries of unknown origin occur for those investigations. So your overall goal for investigations is to get the facts, protect resident dignity, and avoid contaminating evidence. So did we determine if the resident has suffered abuse, neglect? You want to determine the scope, nature, or extent of that maltreatment. You want to hopefully identify the perpetrators of any abuse, assess the impact of abuse on that patient, plan interventions to prevent further abuse and protect all residents, and then plan your initial supportive services after the fact. So investigations should kind of cover all that information. So let's talk about interviews specifically. In your interview process, you're going to interview various people depending on what the situation is. But for sure, you want to have information from the person reporting the incident, the residents involved, any witnesses, interview with staff members having contact with the resident during that time, interview with the resident's roommates as applicable. And if it's something happened in a resident room and they're in an individual room by themselves, you'll want to interview the residents that are in the surrounding rooms to see if they heard anything. Um, you'll also want to interview residents' family members or visitors if it's applicable to the situation. And for sure, you want to interview other residents for potential patterns of abuse that you're trying to rule out. Number one question I get asked is, how many interviews do I do? So ultimately, there's a lot of buildings are doing a ton of abuse reports and doing a ton of abuse investigations, and they can be labor intensive. So I would say at a minimum, 3 to 5 if it's something that like we're pretty sure isn't a huge deal. But I would say for anything that we think is critical, is more than likely going to be substantiated. Depending on the situation, you may want to interview every single alert and oriented person either in the building or on a certain floor. If, like say, for example, the abuse allegation is related to a CNA that provides care, you might want to interview every alert and oriented person that has received care from that person because you're trying to rule out if there's a bigger pattern of abuse or if it's in like just a one-off incident. So when we're talking about interviewing, you want to ensure that you're taking into account cognitive differences, any kind of physical or sensory impairments that the person you're interviewing might have, cultural or linguistic backgrounds, and then you also want to ensure you're bringing in trauma sensitivity to your interview process. Always conduct interviews one-on-one unless the resident's requesting a support person, and you want to ensure that there's privacy and comfort, especially if we're talking about abuse or a traumatic incident for potential abuse that like could be hard for them to discuss. You also want to make sure you're just evaluating their cognitive ability before proceeding, just so that you understand that impairments affect memory, communication, and the potential for consent to have this conversation. So just quick step 1 through 6, know who you're interviewing, understand their vulnerabilities, set the tone for respectful, neutral conversation, use trauma-informed rapport, leverage cognitive interviewing in terms of like ask them about their thoughts about the situation, what kind of sights they notice, their emotions, let that story emerge. Do not use leading questions. And on the next slide, I'm going to talk a little bit more in detail about leading questions. You also want to keep any interviews that you do ethical and transparent. You're not accusing anybody and doing a cross-examination, but you're really just trying to find the facts of whatever happened. Always ensure privacy, confidentiality. And then in this, if you're interviewing, anybody really, but for sure for the residents, observe and document their emotions, their tone, as well as any kind of nonverbal expressions that they might be exhibiting in response to questions. So we often miss that part of a good interview process. So examples of some leading questions like resident safety. You feel safe here, don't you? That is a leading question. So another alternative way would be, how do you feel about your safety here? Asking open-ended questions and letting the answer come out naturally. Care concern. An example of leading would be, the nurse was rough with you, wasn't she? And then alternatively, it could be, can you tell me about your interactions with the nurse? So again, being trained up on using open-ended questions is more valuable for sure in terms of a full investigation that's complete. Other resident interviews are an important piece of ruling out those patterns of abuse. This is probably the next biggest mishap that I see is around other resident interviews, in that we don't tailor interviews to the situation at hand. So if it's a care concern from a nurse or a staff member, and we're doing, do you just feel safe here and have any other residents bothered you? That's not going to get to whether or not staff members have been problematic with care or potential abuse issues. So please ensure that if you are using canned questions, because a lot of buildings do, that you are tailoring those questions to try to rule out whatever the situation is for abuse. So I have here examples of other resident interviews, like the questions that you may ask depending on the situation, right? So like open-ended, and it's just for your reference too. So you guys, when we're done with this, I'll upload this video to YouTube, and then I will link the PowerPoint into um, yep, the calendar invite so you guys can access it, so you guys can review this again at your leisure. But examples of other questions that you might ask for other resident interviews if it comes to staff behavior and treatment. How do staff treat you during care? Has a staff member ever spoken to you in a way that made you feel uncomfortable? And if yes, expand. So if it's a yes/no question, you always want to make sure there's a prompt for any negative finding. Witnessing or hearing about incidents, like this is another one that's kind of we see frequently, but have you ever seen or heard about residents being hit, pushed, or handled roughly? What did you see or hear? Um, Here's some other questions around neglect or supervision, interactions with other residents. Do you feel safe around the other residents here? Has another resident ever made you feel afraid or uncomfortable? Please describe. So these are just some examples for you guys on, some specific areas. It's not an all-inclusive list for sure. Just wanted to get you triggered and moving forward. When we do other resident interviews, you have to know that it may trigger additional reportables. So if another resident is like, oh yeah, Susie Q CNA over there is also hitting me, then you also need to do a new reportable based on that information. You don't just leave that interview in the file folder of the original one for surveyors to find when you hand over your investigative process and they say, oh, what did you do about this situation? It is always possible that you may trigger other additional reportables. The other thing is grievances. So you might not have anything abuse related come out of those interviews, but you might have somebody be like, oh yeah, they don't answer call lights very timely, or the food is cold. Don't just leave that information on your interview forms and not follow up on it. Use your grievance process, fill out a grievance form, and follow it all the way through. You also might trigger some resident trauma responses out of asking sensitive questions about abuse. And in that case, you might need additional staff or mental health support. You might want to ensure that there is documented follow-up to anybody who's having a triggered reaction to any of the interviews that you were doing. Okay, so I have to talk about red flag words. And red flag words, you can find them in really any kind of documentation. I have found red flag words in dental documentation. So I cannot stress to you enough the importance of ensuring that you're reading mental health provider notes, nursing notes, social services, care conference, therapy notes, and looking for red flag words. And these are red flag words that I've seen in different buildings in different areas. I will preface, though, that argument by itself is not necessarily an abuse situation, but the word argument should trigger all of you to dig a little deeper into that situation and ensure that it didn't rise to any kind of level of potential verbal abuse or emotional abuse. So some of these red flag words include mean, rough, ignored, hurt, slammed, abused, demanded, groped, like kicked. Those are all things that could make surveyors go, "Hey, what did you do about this information?" So this is if anything, this slide is a good printable one for making sure that we're screening for red flag words. When we talk about staff interviews, if possible, interview any involved staff in person or by phone to determine their knowledge of any allegation, what information they can provide regarding the allegation of abuse, what their presence or access was in the facility at that time, what details they have of the event, about who, what, where, why, how, when the alleged incident occurred, any kind of observations or explanations that they have around that concern, and then any other additional information. So the note on this page is to always attempt to interview all involved staff, including contract and agency personnel, before taking disciplinary action or ending employment. I have reviewed a number of reportables where we just separated from employment or clicked the little button that says we don't want them back for contract staff, and then we didn't get the information from them about what occurred. So if you can, try to get the information for interviews, for staff interviews done prior to any kind of disciplinary action or ending that employment. Let's talk about evidence. Okay, so if you're one of those buildings that's lucky enough or not unlucky to have video surveillance, you're going to want to review the video files and document the finding and timeline of that event. And the next slide, we're going to talk in detail about what that looks like. As far as tangible evidence goes, physical evidence, you also want to document observations of what that looks like. Do not tamper with potential evidence. And examples of tampering include, but aren't limited to, washing linens or clothing, destroying documentation, bathing or cleaning a resident until the resident's been examined, like a rape kit, if that's associated kind of allegation, or otherwise impeding a law enforcement investigation. Circling back to video surveillance, secure it, preserve it, document it. So you're going to want to pull footage ASAP covering the time before, during, and after the alleged incident. Save it to a secure drive or storage medium that's locked down, meaning limited access, password protected. Make a copy for your investigation file. You don't want to work off the original. Document the date, time, and the person who pulled and saved the footage, because there should be a chain of custody. You'll want to review and document the findings. So the investigator, whoever that might be in the facility, NHA, DON, abuse coordinator, should review all relevant angles and times and document on paper what exactly was observed. So, and the time. The example here, resident A seen sitting in a dining room, 12:04. Resident B approaches from behind. No staff observed in the vicinity. Don't make extra opinions. Don't add inflammatory language to it. Just document exactly what you see. If the footage is inconclusive, you also are going to want to document that. Never show surveillance to other residents, family members, or staff not directly involved in the investigation. Treat that video as protected health information. And then access should be limited with those on a need-to-know basis. So investigators, the administrator, DON, compliance officer, state agency, law enforcement, or legal representation. Okay, now to the fun one, documentation. So things that you want to have as part of your full investigative file. So resident information for involved residents. I have some buildings that do, they do like an investigative file online as part of like a drive that the company has. I have others that print everything out. I don't have a preference, just as long as you can access the information. Ultimately, what I think is good to have in an investigative file is face sheets, diagnosis lists, orders, their most recent BIMs, PHQ-9s, any event-associated progress notes. So that includes nursing notes, care conferences, IDT, medical provider therapy, anything that mentions the event. Anybody that mentions it, you're going to want to print that and have that as part of your file. You'll also want to note relevant behavior and mental health history as it's applicable. If the resident or residents get sent to the hospital, you're going to want to have any kind of documentation from there. Care plans. I think the important thing with care plans is that you have an original that shows like what their current care plan is, and then you can show a demonstrated updated care plan with interventions. I'm not saying print all 57,000 pages of your care plan, but if there's a specific behavior care plan that you had to update because of an incident, like print the original and then print the updated one so that you can show. You'll also want to print any or keep any follow-up monitoring or documentation by any IDT member and or medical provider. There is a huge push for social services to be following up with any resident altercation, any kind of abuse allegation, and have offered either mental health services or additional support. And we need to have documentation that that is occurring. Oftentimes, buildings will have nursing follow-up in terms of like 72-hour monitoring. If that is the case, love that. Print that document and keep it as part of your investigative file. Here's the reason why. If you ever have to go to court or you have to hand over this file to a surveyor, you want to not have to look for all of this information after the fact. You want to show that you did a very thorough investigation beforehand. If there's allegations are related to like misappropriation, you may want to consider adding in the resident inventory or possibly expenditures for receipts for expenditures. So documentation that you may need to have related to staff as part of that investigative file, what immediate safety measures you took. So if you remove staff members from direct resident care, if that abuse allegation is related to staff, you want to document the actions taken to protect residents during that investigation. So that includes potentially collecting staff timesheets, assignment records, recording the exact time staff were notified, removed from duty, left the building, and or were reinstated. You also May want to put in there whether they were suspended with or without pay or reassigned to other non-resident duties. Generally, if it's an abuse investigation, I don't recommend that they just go to non-resident duties, still on campus, still have access to residents. It's just not a risk that I think is great to take. I have had buildings that are like, well, we just put them on two-person care, with another CNA. Again, it's just not a risk that I would want to have to defend to surveyors or in a court, like if, we did end up substantiating abuse. Not saying you can't do it, just a consultant, but that's personal opinion there. You want to have your interviews that you've done with staff as part of your documentation. You also want to have any education or corrective actions that you took as part of your investigation. So if we know that like staff needed, maybe some education on slowing down with care so that they weren't being accused of being rough, that you have that education, you have that in-service sheet, you have that staff sign off on it, and then you have that as part of the investigative file so that you don't have to go searching for it later. You also want to have a final outcome, kind of the summary. And this is all part of, for most states, their portals for their occurrence reporting, right? So totally get that. Some of this might just be copy and paste. Some of it just might be printing out your investigative files. I have some buildings that are not keeping their interviews and are just summarizing it all for the portals. And I don't recommend doing that. I think if you have done the interviews, you've written them down, just keep it all as part of your file. And then just make sure you have documentation of the final outcome. With employee file review, so any person, any employee that's involved in an abuse investigation, you are going to want to look at any personnel actions taken relevant to the incident. So whether we did education, whether we reported them to the governing board, whether we did in-house disciplinary action, that's all relevant. Doesn't necessarily need you have to put their exact information in. You can keep that in the employee file, but you're going to want to potentially reference that in your investigative file. You will also want to review the employee file for history of similar or related allegations. In this, I will also tell you, I think it's important to review grievances for the last 3 to 6 months and see if that person has been involved in any similar related type grievances that might be showing an escalation of behavior from that employee. Review the file for history of related teachable moments, formal disciplinary actions, etc. Review and identify any recent training and education related to abuse and neglect or incidents for the staff involved. Again, it's not something you're going to want to try to track down beforehand. So if you use Relias or some other kind of education training platform, find that information, print it out, have it available. You might find that you actually need to do some updated stuff. You all may also want to check that there's a current OIG check, ensure that the completed background is in place without findings, and make sure license verifications are up to date. When it comes to the police, you want to have documentation that the police were notified for any allegation of abuse. So if there's a case number, you want to note the case number. If the officer came by, gave you a business card, a lot of people are writing the case numbers on the business card, attaching it to their files. If no case number was assigned, document somewhere that the date and the time and the content of the notification to the police. If you can, obtain the copy of the police report. Some will release, some won't. Or at a minimum, document their response to the report. As far as the health department goes, keep and print your initial report, your 5-day summary. If the health department calls and says, hey, we need XYZ more information, make sure you're keeping a timeline of that request and documentation. As far as post-occurrence actions go, you got to have a resident safety plan implemented if it's needed, and make sure you document and update those care plans. They may need a medical evaluation by the physician or nurse practitioner or PA if that's indicated. If that's the case, ensure that you have that as part of your file. Any follow-up by social services and what they offered, ensure that's in the file. And then again, any progress notes from nursing, social services, IDT, etc. As far as leadership and compliance goes, generally it's the administrator or director of nursing that should be kind of directing the investigation, if not responsible for the investigation. That doesn't mean that they're doing all pieces of it. They may be farming out the interviews to different management or to social services to complete. If you have a separate abuse prevention coordinator, that person needs to be involved in any kind of abuse investigation and consulted. And then again, QA needs to be informed. They need to be reviewing incidents, trends, response monitoring, and reviewing facilities, policies, and procedures. It will also mention that medical director expectations was increased in the most recent regulatory update, and they are expected to have far more oversight into what is going on at buildings. So I would make sure that your medical director is aware of, especially things that we think we're going to substantiate, that they are aware of it, that they could do a chart review, have that opportunity, and that for sure that they are aware of any trends in reportables that we're seeing. As final review and closure of your investigative file, do your completed 5-day report and have that printed or uploaded. Ensure your actions are documented. Ensure all your required reports are completed, that your final determination is made, that your risk management, I really recommend that people do risk management reports for any kind of resident to resident altercations, staff to resident, whatever, neglect, any kind of allegation. It is risk management. And it can help in tracking and trending and keep that organized a little better, especially if you use PCC. If your company has a reportable checklist and they expect you to do it, make sure that it's complete all the way through. And if it's not, document the rationale for why it's not completed. We have one at Granite Peak that we kind of share with people as we go. This is just page 1 of it over here on the left-hand side. Just kind of gives you an idea. I always tell people I really think that it's better if you use this as a guide versus like attaching it to your every file, just because there's some things on here that are going to be applicable and some that aren't, depending on whatever the situation is. There's also an app out there, shameless plug, the LTCSOM Regs app makes it easy to kind of look up the regulations in case you want to get some more information directly from there. It is on iTunes and Google Play. Okay, so I am 1 minute over. Those are the resources. Let me get to the questions, and I am going to pause recording